all of these companies, Meta, Google, the artist formerly known as Twitter, they all have different manners in which they, in their view, make their platforms better for society. They have algorithms, they have content moderation, they allow certain people on the platform, they kick certain people off. We all know who I'm talking about. They have just different things that they do that are content they allow and content they don't allow. Many people think, and particularly the governments of Florida and Texas, but they are not alone, that this content moderation that the companies engage in is in fact slanted against call it Republican voices, call it conservative voices, that they're sort of promoting liberal political ideas, promoting liberal ideology, and are suppressing more conservative voices.
Good afternoon. I'm Dan Winslow. I'm the president of the New England Legal Foundation. Before I introduce our presenters, I just want to start with a moment of gratitude. Our thanks to the lead sponsor of today's program, the law firm of Weil Gotshal, for making this event and the reception afterwards possible. Our thanks as well to Revolutionary Spaces for the use of the Old South Meeting House and making events like this possible. Our thanks to WGBH for live streaming this event so that more than 120 people can participate online to today's discussion. My huge thanks to our Director of Membership and Events at the New England Legal Foundation, Elizabeth Miner, and our Development Associate, Cameron Sapienza, for all of their hard work to make the event possible. And I want to thank all of you who came out on a rainy Boston afternoon to join us here in person. We're in the last weeks of the term of the United States Supreme Court. Many of the cases have been decided, but the cases yet to be decided offer some of the most complex, challenging, and controversial issues of the day. Each of the decisions in the forthcoming weeks will be newsworthy. We've assembled a panel of Supreme Court experts, practitioners, to tell you about some of the cases that remain and to offer their predictions about what they think the justices will decide. Our panelists today include Zach Tripp from the law firm of Weil Gotshal. He's the co-head of Weil's Appeals and Strategic Consulting practice. Zach previously served as law clerk to Justice Ruth Bader Ginsburg and has extensive experience in practicing before the Supreme Court. Edwina Clark is with us from the law firm of Goodwin Proctor. She's a partner in the litigation department and a member of its appellate and Supreme Court litigation practice. Edwina clerked for two Supreme Court justices, Justice David Souter and Justice Stephen Breyer. In the middle is Felicia Ellsworth, co-chair of WilmerHale's Litigation and Controversy Department and the partner in charge of the Boston office in the firm. And she clerked for Chief Justice John Roberts. And last but not least, Jeremy Christiansen, to my immediate left, a partner at Gibson, Dunn, and a member of the firm's, among other practices, the Appellate and Constitutional Law litigation groups. And he clerked for the Federal Court of Appeals for the Ninth Circuit, as well as for Justice Thomas Lee of the Utah Supreme Court. Our moderator today is Professor Akhil Amar from the Yale Law School. Professor Amar is the Sterling Professor of Law and Political Science at Yale, where he became a member of the Yale faculty at the age of 26. Professor Amar clerked for Judge Stephen Breyer before he became Justice Stephen Breyer, no doubt owing to his great success later in his career. And Professor Amar has generously offered to sign copies of his latest book in the back of the room at the publisher's price. And so we're happy to have that available to you during the reception. We're going to be discussing the cases for about an hour, followed by 15 minutes of Q&A from the audience. If you'd like to ask a question or share a comment, just wait for the microphone to come to you so that the online audience can have the benefit of your thoughts or your questions. And for those of you who are here in person after the event, we will offer refreshments, beverages, some light fare, and conviviality after the presentation. So without further ado, on behalf of the New England Legal Foundation, it gives me great pleasure to turn the program over to Professor Amar. Thank you.
Thanks, Dan, and thanks to New England Legal Foundation. Thank you to all of you in person and to our broader virtual audience. We're grateful you're choosing to spend some time with us. Just as a matter of personal privilege, I just want to say how wonderful it is to be back in Boston, where I spent one of the best years of my life clerking for then Judge, later Justice. I'm gesturing to someone who clerked for him as a justice, Stephen Breyer, who's of course himself back in Boston. I lived at Charles River Park. I don't know if the sign is still there. If you lived here, you'd be home now. And I feel like I'm home now. So thank you very much for this homecoming. We're going to start off with some discussion of some administrative law cases. And Zach and Jeremy are going to kick us off. I just want to, you have the bios, but just a little fun fact about each of them that you might not get from the bios. Zach has argued a dozen cases before the United States Supreme Court, and that's very special. We're going to be talking about, obviously, the Supreme Court today. We're going to be talking about judges throughout the system, because what the Supreme Court does is review cases coming from below. And Jeremy is distinctive, not just in reminding us that it's possible to get a very good education, both undergraduate and law school, west of the Mississippi, in the great state of Utah, but as you just heard very briefly, he clerked for a judge in the state Supreme Court system and a judge in the federal appellate system. So that's somewhat unusual. In this town, I was actually giving him a pop quiz, who are some of the most famous people who did both of those? So just in greater Boston, that would include the great Larry Tribe and the great Cass Sunstein, among others. Jeremy and Zach, why don't you get us started, please?
So thanks for having me, really appreciate it. Just wanted to start by talking about a case called Loper Bright, and really in the last 10-ish years at the Supreme Court, there's been a lot of attention on administrative law, the power of the administrative state, administrative agencies, and a lot of skepticism, I would say, from the current Supreme Court of the power of administrative agencies, the sort of alphabet soup of agencies in the government. And the Supreme Court there's been, I think, something of a trend to sort of curtail their power. And the case that's up this year is perhaps the most significant of them. It raises a very serious question. And sometimes Supreme Court cases, they raise big questions, involve like really big facts. I think we'll talk about some of them later. But this one's like a little case. It's about fishing boats in New England. It's about the New England herring fishery and a requirement by the National Marine Fisheries Service. They have the power to require these fishing boats to have a federal monitor on board to be sure that they're not catching too many herring. But the real question in the case is who pays? Who pays for the monitor? And the law that gives the agency this power doesn't really say. It's not immediately obvious, at least if you're reading the law, who is supposed to pay. And you will be shocked to learn that the government thinks that the fishermen should pay, and the fishermen think the government should pay. And the case, this like little dispute, turns on the answer to something called Chevron deference, which is under Chevron, this is one of the most famous cases the Supreme Court has really ever decided, is if a law is ambiguous, if it's not clear, then the courts are supposed to defer to an agency's reasonable interpretation of its own statute. And so the lower court here said, I look at the statute, I don't immediately see the answer, it's reasonable to require the fishermen to pay, therefore they win. The key question in this case is whether that is still a sort of a valid way of approaching these admin law questions. That was established by a case decided in 1984 called Chevron that lower courts have followed many thousands of times. But in the last 10 years or so, there's been a lot of criticism of that decision as going too far in giving agencies power that really should belong to the courts. And in particular, there's been a lot of criticism from the sort of right side of the bench. Justices Gorsuch, Kavanaugh, and Thomas have all written about this as an issue. And the Supreme Court has not relied on this doctrine in the last 10 years. It's done it once in the last 10 years, even though they've had many opportunities. this is a kind of doctrine that makes it much easier for courts to resolve cases. All they need to know is that the statute doesn't answer the question, and then it makes it very easy to rule in favor of the government. And the Supreme Court has not been going down this path in recent years, and the question now is whether they're going to jettison it. I don't want to spend sort of too much time getting down into the details of it. I think one of the things that's just sort of interesting about this case, there's sort of a menu of options, as there often is in front of the Supreme Court. It's not a binary yes-no type of question. They could overrule this earlier doctrine and throw it entirely out the window, but they could also narrow it and cabin it and be clear that agencies have some discretion and some leeway to establish policy, but maybe less than is currently understood. And so there's sort of a menu of options. In the oral argument, you see the justices sort of struggling with how exactly to articulate it. I think I will go out on a limb and make one prediction, which is that I would be very surprised if the bottom line judgment says affirmed, the government wins. This is one of those cases where it seems like the fishermen are going to win, but the question is really, what is the opinion going to say? What is the court's reasoning going to be? And how much are they going to constrain the power of agencies along the way? That's the action.
Really brave prediction.
So I will pick up on this theme, and I just want to reiterate a little bit of what Zach said about this broader discourse of administrative law. So I drew 2/3 of the administrative law straw for this discussion. And Zach is absolutely right that over the last decade or so, there's been a very clear shift at the court in which the court has become increasingly more comfortable, or some might even say aggressive, putting in checks on the administrative apparatus of the federal government. And this kind of fits into this broader discussion where you have proponents of those decisions that have limited agency powers arguing that this helps further interests like the separation of powers and ensuring that the right branches of our government are the ones making decisions, and that those that are politically accountable are the ones making decisions. And you see sort of defenses of these kinds of positions and pointing out that the administrative state, to put it somewhat mildly, can fit a little bit uncomfortably with the text and the structure of our Constitution. And so you would see these kinds of views from, say Professor Philip Hamburger or Gary Lawson, who have made arguments that I think have been influential in this sphere, as well as many others. On the flip side, you have critics of these decisions who have said, well, we think that maybe some of these sort of neutral interpretive principles that the court claims to be applying in doing these things are really smuggling in some normative judgments of political morality and are curtailing the government's ability to do what it really rightfully ought to be able to do, which is govern in some of the more complex areas in our modern world, in our modern economy. On that side, I would say, you'd say Cass Sunstein or Adrian Vermeule sort of fit into this. Now, that sounds kind of highbrow, but I wanted to raise it because I think it is very interesting of how much those debates really matter at the court. And if I were to make a long ball, crystal ball prediction, looking back decades from now, people will look at the Roberts Court, and I would think that one of the defining characteristics of the Roberts Court will be this wrestle that it has had with the powers of the administrative state. So another case that raises a very serious question is called SEC versus Jarchese. So the Securities and Exchange Commission is, of course, a federal agency that administers our federal securities laws. And the SEC can enforce those laws civilly, not criminally, but civilly in sort of two ways. So one of these ways, it can bring an enforcement action in federal court, or another thing that it can do is they have sort of in-house courts that administrative law judges run. and they can run those proceedings in-house. Now, what happened in Jarchese is that you have a man, I forget his, George Jarchese, so it was alleged that he had violated a number of the federal securities laws, and they brought an in-house proceeding against him, and the administrative law judge said, you committed some securities fraud, and the full Securities and Exchange Commission affirmed that ruling, and they imposed a fine of, I think, $300,000 or so, made him disgorge profits, and then barred him from operating in the securities industry. Now, the case went up to the U.S. Court of Appeals for the Fifth Circuit, and the Fifth Circuit reversed, and it did so on 3 different grounds, all of which sort of involve these big questions of the separation of powers. The first was whether having these in-house administrative law proceedings violates a person's Seventh Amendment right to a jury trial. And that's provided by the Constitution. And there were 2 other arguments. One, that there is a problem under what's known as the non-delegation doctrine, which posits that at some level, Congress cannot delegate certain powers away to the executive branch, in which the SEC sits. And then the third basis was to, sorry, I lost my notes here. They had 3 of them. So the third basis was on removal. So there are provisions in the Constitution that govern whether the president can remove certain operators in the federal government for cause or for whatever reason the president likes. Now, the latter of these 2 did not get a lot of attention in the Supreme Court's argument. They were barely mentioned. The non-delegation doctrine is often a challenge for people bringing that up. But the oral arguments focused intently on this Seventh Amendment question. And sort of a rough take from the arguments is that you have the 3, what we might say the more liberal justices, Justice Kagan, Justice Sotomayor, and Justice Jackson, seemed inclined to say that this is okay because of a thing called the public rights doctrine. That if certain kinds of cases involve public rights rather than private rights, it's okay to not have them tried before a jury. But if something is a private right, if it looks a little bit more like what used to happen in common law, well, that's the test that triggers, you have a right to have a jury decide that question, that Mr. Jarchese would have a right for a jury to say, did you violate the securities laws, rather than effectively something like an employee of the federal government make that decision. And the 6 more conservative-leaning justices all seem to be very keyed in on this question about the Seventh Amendment. The real struggle is sort of a bit like Zach pointed out for the Chevron case of sort of where do we draw the line? This public rights doctrine has kind of bedeviled the courts for a long time. It can be difficult to draw a line between what exactly is a public right and what's not.
It's like one of the most confusing areas of all federal law. I don't think anybody understands where the line is drawn.
Yeah, it's very challenging, and what you and so what you have is, I think, brooding behind there, the consequences also of this decision. There are a number of federal agencies that it can impose various civil fines and penalties. And so it poses a question of a lot of the ramifications for, how many other federal agencies have similar in-house adjudication that could be declared unconstitutional. I think if I had to make a prediction, I would say that the justices seem inclined, or a majority of the justices seem inclined, to think that there is a problem with the way that certain claims are adjudicated in-house at the SEC. And I think it also fits into this broader pattern of, sometimes in more dramatic ways, but sometimes in sort of lighter touch ways, curtailing the powers of administrative agencies and pulling some of those powers back into the wheelhouse of the federal courts.
Great. So before we move to the next area, which is issues of free speech, First Amendment-like issues, just a few quick thoughts. We didn't rehearse all this because we wanted it to be spontaneous. So I want you all, we're in the Old South Meeting House. This is where people met. Sam Adams over there was in communication with other folks right before the Boston Tea Party, and James Otis and other people made a lot of trouble in this building. And what were they making trouble about? I want you to know your history. This is a homecoming. And by the way, the history is in the book that I want you to actually get, because if you don't know your history, no, I'm being serious here, we all die. Okay? And you all can tell me something very interesting about Ted Williams or Tom Brady, and how Williams compares to other hitters in history. Very well, by the way, or Bill Russell in basketball. Oh, very well, by the way, or Larry Bird. I know what town I'm in, or Brady, but you can't, but you don't know your presidents and your justices and your history, and if you don't, we die. Okay? So, the book will give you the first 80 years of American history, 1760 to 1840, and here's what I tell you, and it's relevant to this. It begins in the old State House, just a few steps from here, where there's actually a court case led by this rabble-rousing attorney named James Otis, all about the writs of assistance. And the writs of assistance are pissing off people like James Otis, because the government is going after smugglers, but it's doing so using actually non-jury procedures, using things called vice admiralty courts. And just like they're going after Jarchese, you see, without a jury, and that annoys a lot of, because believe it or not, people in Boston, this town is based on a lot of things, but one of them is smuggling. Okay, because a jury is going to be much more sympathetic to the alleged smuggler because they keep prices down, you see, for consumers. So that's what leads to, in part, a lot of controversy here in Boston with the writs of assistance. It's going to lead to the Stamp Act, and this is about what happened here in Boston. Now, on the other side, what the SEC is doing it's part of a complex regulatory scheme and involving who can issue stocks and bonds and with what sorts of special rules, Sam Bankman-Fried-like stuff. And our jury is going to be able to understand all the complexities of registration, of remedy, of lifetime bans, and all the rest, or do you need administrative agencies? Okay, so did you talk about really the funding of the CFPB?
So I was ready to roll there too. We've got another one. If you want to talk about the most, if I had to say there's one agency that's caused more controversy in I guess my short lifetime, it would be the CFPB, the Consumer Financial Protection Bureau, which was birthed in the wake of, it was part of the Dodd-Frank Act, in the wake of the Great Recession. And the CFPB has sweeping powers over many, if not most, areas or at least it says, over most areas of America's economy that affect consumers. And the agency has faced a number of constitutional challenges to its structure over its relatively short lifetime. The first being the insulation of the chief of the Bureau from the president, that the president can't just remove that individual. So that's an issue that's gone up to the court. And one of the very unique aspects about the agency is the way that it is funded. So in the statute, it says that the agency is going to get its budget, it gets to draw from the coffers of the Federal Reserve. So, and then it can take as much money as it needs up to a cap, I think it's something like 12% of the budget of the Federal Reserve, which is a whole lot of money. And so in this particular case, there was a rule that the CFPB passed, and the challengers, among many other things, argued that the way that the CFPB is funded violates the appropriations clause of the Constitution, because you don't really have Congress saying, well, okay, here's the bill and here's your money and this is how much money you get, and you do it. Rather, it's this unique system where the agency goes and takes the money from another agency that also has a lot of insulation, obviously, from Congress, and a kind of a staggering amount of money. So the Fifth Circuit held that this is unconstitutional. It is the first time that there's ever been a ruling that a federal agency's funding violates the appropriations clause. And they ordered as a remedy, well, you know, you brought this lawsuit against these people using the money that you drew unconstitutionally, so case dismissed. And this question has made its way up to the High Court. And the oral argument was really fascinating, because it seems that everybody can agree that somewhere there's a limit about how much unspecified funds Congress could say, you know, and still have it be an appropriation. And so the oral argument was full of hypotheticals of, well, what if the law said, in order to enforce the consumer laws of the United States, Congress hereby gives the CFPB or the president the power to draw $2 quadrillion each year for as long as he sees fit in order to run that. That effectively what that's done is it's just transferred the power to appropriate money over to the executive branch of the government. And everyone seems to agree that the $2 quadrillion thing would be a problem. But the really sort of bedeviling issue is, okay, well, where's the line? As Justice Elena Kagan pointed out, we're not talking about $2 quadrillion. We're talking about 12% of the Federal Reserve's budget, which is, I think she said, a rounding error in the U.S. federal budget, right? Not a whole lot of money. The real impact, though, they did not spend a lot of time talking about remedies. This is something that consistently bothers me, not least because I've had cases in which we have been pushing this, and the Supreme Court has routinely sort of decided not to really say what kind of remedies a party would get for separation of powers kinds of violations. But one of the real issues is, okay, what if their funding is unconstitutional? That's one thing. But then what do we do about that? The number of regulations and rules and enforcement proceedings that the CFPB has brought is many. And so the government defends that by pointing out this could cause a lot of problems. And the government, this gets to Professor Amar's point about history. The Solicitor General very pointedly began and focused her very skilled argument and defense on historical analogs from the founding era of various federal agencies and departments that were funded in similar ways, but did concede at one point, under some questioning from Justice Alito, I can't give you one that's exactly like this. They're all quite close, but not quite like this. So
we said crystal ball gazing. I'll tell you what will happen, and I'll look like a fool in a month, and I'll tell you what should happen. Okay? What should happen? No taxation without representation, but yes, taxation with representation. Congress signed off on the thing, done. And Brett Kavanaugh, at oral argument, said, gee, here's a line and it's clean. Congress could repeal it tomorrow, and that seems to suffice. Now, here's the complexity. If the money were given directly to the president for his personal use, the problem is when you try to repeal it, there's going to be a veto, but that's less of a problem when you're not giving it to the president himself. That's a brilliant argument from Professor Amar, but it's not Akhil Amar. It's actually my kid brother who did clerk for the Supreme Court. I didn't. Professor Vic Amar, and if you want to read it, it's called Direct Effects of Indirect Election. So the problem is when Congress gives something to the president and then wants to take it back, the veto power creates a certain complexity, but probably not at issue here. The Fifth Circuit's going to get its butt kicked, and deservedly so, because they're way the heck out of line. And this isn't going to be the only case where they're way, way, way too far ahead. And maybe they haven't done this before, but before there was an Air Force, there wasn't an Air Force. And before there was Social Security, there wasn't Social Security. So that's not a great argument. Here's what's a great argument. No taxation without representation. That's what the Stamp Act was all about. That phrase was coined by James Otis in this town, and he used to hold forth in this building a lot. But the flip side is here, Congress actually did sign off on it. And if the court starts messing with Congress's power of the purse, they should expect some big pushback from Congress, because Congress isn't going to like that very much, and it funds the judiciary and everything else. One final point, and then we're going to talk about the First Amendment and freedom of speech. Since Zach mentioned fisheries, you should know that the American Constitution was basically all about New England fisheries. What happened is John Jay was making a treaty with a guy named Gardoki, and this is under the Articles of Confederation, and he was saying, if you give us all sorts of fishery recognition, cod banks in Newfoundland, we'll give up navigation of the Mississippi River for 25 years. Now, this pitted Americans from one region, New England, against Americans from the other region, Trans-Appalachian Kentucky and Tennessee, it was then called Franklin. Their lifeline is the Mississippi River. And so American history is all about fishing and smuggling and taxes, and it's all about Boston, okay? And you need to know your history, because we're relitigating all of that today. Now, freedom of speech. We're going to get two other folks now into the conversation. Again, I'm trying to give you some interesting things you won't find, on the cover sheet. So, Felicia Ellsworth clerked for the Chief Justice. What's particularly interesting, see, these are true facts. People who are named Dennis are far more likely to end up being dentists. People who are named Lawrence are far more likely to end up being lawyers. This is true. You can Google it, okay? Now, her last name is Ellsworth. Ellsworth was a Chief Justice of the United States Supreme Court, and she ends up working for John Roberts, Chief Justice of the United States Supreme Court. So, very interesting. Now, my friend Edwina here, here's a fun fact about her. She's clerked, it was mentioned briefly, for two justices, Souter and Breyer, both of whom sat in the United States Court of Appeals for the First Circuit before they were on the Supreme Court. But all told, she clerked for 5 federal judges, 3 others. I think that's a world record, that the final jeopardy for, a question. But also, you should know that increasingly in our world, the people who are on the Supreme Court clerked for justices and judges. Okay, that's actually increasingly how you become a justice, is you start by clerking. They all did multiple clerkships. I didn't, okay? But Edwina did 5, and I think that's a world record, and they're going to tell you, Felicia and Edwina, about free speech cases.
Okay, well, I think the analogy would work better, not if I clerked for the Chief Justice, but if I became the Chief Justice.
I'm saying you might. Okay, this is crystal ball gazing. Pay attention to these folks, because they've got the CVs. They've got the resumes that put them in contention.
Okay, so I'm going to talk about 2 First Amendment cases that I'm going to group together, and the Supreme Court also grouped them together. One is Net Choice versus Moody, and the other is Paxton versus Net Choice. You'll notice there's the same party in both of them. The first, Moody, relates to a Florida state law that was passed essentially trying to regulate social media companies. The second case is a Texas law, Ken Paxton, that was also passed trying to regulate social media companies, and we'll talk about how that implicates the First Amendment and what it means. One thing that's a little bit interesting about the captions here is, of course, they're flipped, because the 2 circuit courts, 11th Circuit for Florida, 5th Circuit for Texas, came out 2 different ways with these 2 different laws. So in Florida, the law was passed. The Florida District Court entered an injunction, said this law violates the First Amendment. You can't regulate people's speech, and by regulating these social media companies, you're regulating speech, violates the First Amendment, enjoins the law. 11th Circuit upholds that injunction. In the Texas case, now the laws are different, of course, and that may be part of the prediction ultimately here. The Texas social media law, I'll call it for shorthand, was enjoined by the district court, but the 5th Circuit overturned that injunction, said, no, this law can go right into effect, no problem at all. The Supreme Court flipped that, reinstated the injunction, at least for purposes of considering, first at the time it was considering the Moody case, and then ultimately decided to take up the Paxton case too. So the cases weren't consolidated, the laws are different. Most of the same advocates argued, so Elizabeth Prelogar, the Solicitor General, argued in both cases. Paul Clement argued for net choice in both cases. He's another very gifted oral advocate. And then the two respective Solicitors General of Florida and Texas argued for their states. So what's at issue? The question is whether these states can pass laws that regulate how social media companies, and I'm using social media as kind of a shorthand here, and there's an important distinction that I'll get to in a minute, ability to regulate their platforms. So all of these companies, Meta, Google, the artist formerly known as Twitter, they all have different manners in which they, in their view, make their platforms better for society. They have algorithms, they have content moderation, they allow certain people on the platform, they kick certain people off. We all know who I'm talking about. They have just different things that they do that are content they allow and content they don't allow. Many people think, and particularly the governments of Florida and Texas, but they are not alone, that this content moderation that the companies engage in is in fact slanted against call it Republican voices, call it conservative voices, that they're sort of promoting liberal political ideas, promoting liberal ideology, and are suppressing more conservative voices. And so both of these laws were passed in an effort to stop the social media companies from using their algorithms, using the various manners in which they regulate their platforms in a way that, again, in the views of these state legislatures, would suppress certain types of speech. The social media companies, that's net choice, but it's sort of an industry organization, say, no, we are not suppressing anyone's speech. It is our speech that you are suppressing. Our right to regulate the content that we see on our private platform, we're private entities. Our right to regulate that is our own speech, and you can't regulate that. This is just a straightforward First Amendment violation. So at the Supreme Court, what have we seen? Now, before I get to the arguments and the predictions, there has been a steady drumbeat at the Supreme Court and in some other fora, including in lower courts, of voices, footnotes, concurrences suggesting that these companies, these fora, are the new public square, right? That they maybe should be treated more like a common carrier than like a private entity, because we live our life online and they are sort of the barometer and regulator of information that people get. And so there is some argument by the states that essentially these should be treated like common carriers, right? Who have to be open to all, who can't censor, who can't have any kind of, who have regulation, but they can't have any sort of choice about who can speak and who can't. The social media companies respond and say, no, we're the New York Times. We are Thomas Paine, right? We are just publishers of content, and we can decide in our private publication what content we want to include and what content we want to exclude. That is our First Amendment right. So it's sort of this tension of First Amendment rights that we see at the court. Some of the questioning and some of the points that are made at the oral argument from people who are maybe more skeptical of the technology and social media companies' arguments is, how does the First Amendment protect the right to censor, right? This is turning the thing on its head. I will say that the takeaway from the arguments was largely that the laws seem unlikely to stand, at least in their entirety. Both of the cases are facial challenges. They hadn't yet been applied against any company or any entity to regulate the manner in which they operated. These were laws that people saw coming from miles away. They sued to enjoin them the day they went into effect. Everything acted, both the courts acted quickly. There's no record. And so it's really a question of kind of, does this concept work? And I think we'll probably see a somewhat narrower ruling from the Supreme Court that you can never do this, particularly because for the Solicitor General, for the federal government, for the Biden administration, it's really hard for them to argue, oh no, these companies should be allowed to do whatever they want, because they have their own issues with these companies. So there's sort of a political angle to this as well. But I do think that we'll see some commentary, as we have in prior decisions, from different members of the court, or maybe even from a majority of the court, that there can be some regulation of these companies and these services. That it's not that they're unregulable, it's that the manner in which these two states have chosen to try and regulate them violates First Amendment principles and violates maybe some overbreadth principles. So one of the distinctions between the two laws is the law Florida put together is not as narrowly drafted or tailored, and so a lot of the focus at the argument on Moody related to what other kind of companies other than these sort of paradigmatic social media companies might be swept up in it, including other technology companies that we don't think of as engaged in speech, like rideshare companies, like Google Messenger, things like that that are just very different than maybe what we all have in our mind as a social media company. So there may be a sort of fails at the outset on an overbreadth kind of ruling on the Florida case, but I think they'll have to grapple, in at least the Paxton case, with this question of both the extent of the First Amendment and also sort of the extent of regulation that is permissible for these types of entities. So my prediction, I'm going to make another brave one, which is I don't think these laws are going to stand in their entirety. I'm not sure that they're also going to be struck down in their entirety. I think we'll probably see the usual, an opinion and remand with instructions, to enter a judgment consistent with this opinion, which is usually a recipe for some lower court additional skirmishing about what that actually means.
Okay, so I have Murphy versus Missouri, and I think I got lucky. I have two cases that I think have fun facts, so we'll do a little bit of facts. So Murphy, we've got 5 individuals in 2 states, and the states are Missouri and Louisiana, and they sued the federal government because around the time of COVID, these individuals were posting various things about COVID-19 and also about the election. And to give you some examples, some people were posting about the lab leak theory surrounding COVID-19, vaccine side effects. There was some posts about the Hunter Biden laptop story. And these people had their posts either demoted or removed. And their claim is that this was done by, yes, the social media companies, but really behind the scenes, the government was pulling the strings and pressuring and coercing these social media companies to remove the posts. So they sued. And the district court entered a preliminary injunction, said you're likely to succeed on this, and the Fifth Circuit affirmed. And the rule the Fifth Circuit articulated was that the federal government officials had violated the First Amendment by either coercing or significantly encouraging these social media companies to remove or demote these posts. So that was the standard. And the government went to the Supreme Court and they asked, please take this case, and they also asked, please stay the injunction. And the injunction they entered was quite broad. It basically said various divisions in the government, including the FBI, the White House, cannot communicate with these social media companies. And it applied not just to the companies that were involved with these 5 individuals, but it was broader, applied to a lot of companies. And the Supreme Court took the case, and they also stayed the preliminary injunction. So right now, the government can continue to communicate with these social media companies. 3 of the justices, Justices Alito, Thomas, and Gorsuch, dissented from that decision and kind of tipped their hands a little bit on the merits. And they called the facts highly disturbing in the case. And they talked about, the facts, all these emails and communications from the government to these social media companies saying, please take this stuff down. So there are actually 3 issues on which they granted cert. The first is standing, and the kind of, there are lots of standing issues here, and there are standing issues for the individuals, and there are standing issues for the states. And so for the states, for example, there's this question of why do the states have a right to sue on behalf of these people, and the states say we have a right to listen to our constituents and hear what they care about. And the government says, well, if that's true, anybody can sue. But the issue that was really central argument was this idea of traceability. So to sue, you have to have an injury, but you also have to show that it's traceable to the actions of the defendant. And so the key issue here is, yes, these posts were taken down, but they were taken down by the social media companies. Can you trace that to the government's pressuring, or did the government just say, hey, social media companies, these issues are bothersome, and the social media companies looked at their own policies and thought, yeah, this is problematic to us, we're going to take them down, and so those it's not really traceable. So that came up at argument. On the merits, the crux of it is, in order to be liable under the First Amendment, does the government have to coerce, or is it enough if the government does what the Fifth Circuit said, which is significantly encourage the social media companies to take down this content? And then kind of within that, there was also this facty fight about what did the government do here? Like, were they just, significantly encouraging? Were they coercing? Were they threatening antitrust action? So that was the central that was the central dispute on the merits. And then the last issue was kind of, is the PI too broad? Like, should it be limited to just the companies who are at issue here? Is it too broad in terms of its application to various government agencies? So Crystal Ball. My sister told me I should wear a turban for this, which would have been funny, but I didn't. But I think it's unclear where it will be decided in terms of standing versus the merits. But I don't think the decision's going to stand. I'll even put a number on it. This is really aggressive, but I think if it gets to the merits, I'm not going to put an exact number, but I think it's going to be at least 6-3 on the merits. And I think it might even be more. And what I think the argument was a little bit disappointing. I think what happened is that the Louisiana Solicitor General came out and was just going really far. He said persuasion's enough, and the justices, most of the justices seemed bothered by it, and there were a lot of interesting hypotheticals, and I'll give you a few of them. So Justice Kagan and Justice Kavanaugh both have worked in the executive branch, and they basically said, what do you mean this happens thousands of times a day, that the government calls up the New York Times, the Washington Post, and says, what are you doing posting this op-ed with all these false claims? Like, stop doing this. And how is that really a First Amendment violation? And the Solicitor General of Louisiana said yes. And so they were skeptical. What were the other hypotheticals? Justice Roberts was finally chimed in and said he had no experience coercing anyone, but that he was skeptical. So that was amusing. Justice Jackson had a hypo where she said, suppose there's a TikTok challenge. And the TikTok challenge is getting teenagers to jump out of windows at successive heights. And the FBI sees this and calls TikTok and says, you've got to look into this. This is dangerous. People are going to get hurt. People are dying. That was her hypo. And again, the Louisiana Solicitor General, didn't really back down from that hypo. And then Justice Barrett had a hypo and said, suppose you are doxxed and others are encouraging harming you, and the FBI calls social media and says, you got to look into this. This person's going to get hurt. Does that do it? Is that enough? And the Louisiana SG said yes. And Justice Barrett said, she was just really incredulous. So I counted up. I thought you have at least 5, and then I think Justice Sotomayor, I think you have 6 who really do not like how far the proposed standard is in terms of what would count as a First Amendment violation. But then there is the standing issue. I think it's possible they do it on. I don't know enough about the facts in terms of the communications here, but Justice Kagan did say at one point, can you give me your best example of a situation where, show me your best example of where there's a connection? And the Louisiana SG said this one plaintiff, Hines, had her post taken down 2 months after the government reached out. And Justice Kagan said, well, a lot can happen in 2 months. So that seemed a little weak. But then Justice Alito pointed out that traceability is a factual matter. It's usually reviewed for clear error, so shouldn't we just defer to the district court in terms of whether there's traceability? And then on the injunction itself, Justice Gorsuch seemed quite concerned about how expansive it is. So anyways, I don't know which of those things it's going to come out on, but I do think if it gets to the merits, I think it's going to be vacated and remanded with a coercion type standard.
So the theme thus far is that these federal judges, appellate judges in Texas on the Fifth Circuit are going to get their butts kicked. And deservedly so, because they're just doing a whole bunch of right-wing meme stuff that's not actually sound, okay, on how you fund government. Here's, a bill sitting on Capitol Hill, and it has to actually pass the House, and if it's a revenue bill, it has to originate in the House and then pass the Senate and then get signed by the President, and that was the bill for the Consumer Financial Protection Bureau, and that's what the Constitution says, okay, and they did that, okay, so they were way too far out on that. Now, on net choice, see, there's this fundamental, it sounds so technical, the state action doctrine. All of your freedoms depend on it. Your rights are against the government, okay? The government can't do certain things, can't censor. Oh, but actually private entities can. It's called freedom of the press. They get to decide what to publish and what not to publish. That's censorship. That's okay. And the most important publisher, maybe in all of American history, was born in this city, and his name is Ben Franklin, and his family is buried just, 200 yards from where we are now, so you need to know your history. He is the Rupert Murdoch of his era. He has a chain of newspapers up and down the continent, okay? And by the way, don't tax paper, because that's his biggest cost, is paper. And if you tax paper, that's called the Stamp Act, newspapers are not going to like that, and they will push back against that, okay? So that's the Stamp Act. It's no taxation without representation, and don't tax the press. Don't tax paper. So the Fifth Circuit was way out ahead in saying, oh, let's treat these media companies as if they were the government. Well, if you do, then there's no private freedom left anymore. And New England, the NELF should actually care about private freedom. You say, oh, well, they're monopolies. They're monopolies for 30 seconds, and then they're not, okay? So there's this company. Today it's Facebook, and now tomorrow it's Instagram. Oh no, it's really Google. No, it's really Apple. No, it's really TikTok, whatever the hell that is. And it will be something else in 3 minutes, okay? So markets in general in America, there were all these important, there used to be these things, they were called newspapers, okay, and now they're not quite, okay? So private entities rise and fall, and people will actually subscribe or not, and when the government starts telling them what they can do and what they can't do, you should all be very nervous, and the Fifth Circuit was way out over its skis on this. Now,
thing about these cases. So there's a lot of ripple effects, I think, from all of these cases we've been talking about. There are a huge number of actual cases backed up in the courts because of Murthy, right? There's a number of cases that were brought, particularly coming out of 2020, both COVID and the election, brought against companies, social media companies and other companies for allegedly violating free speech, and the defense is we're not a state actor. So the outcome of whatever guidance might be provided will be very relevant for those. There's also a large number of actual litigations and cases that have been filed, and other states that are waiting to pass legislation that have a question about how you can regulate these companies. So there's like a real backlog of both actual cases and then potential new laws and potential new legal issues that I think from these 3 cases we've just been discussing are potentially implicated. And then obviously the administrative law.
Yeah, and also I think just there's been a number of just social media cases in the Supreme Court in the last number of years. The Supreme Court sort of has like a delay of a number of years from when something happens in our society before it hits the court. But social media has hit the court in a big way. They've had significant cases about social media in the last couple of years, multiple of them this year, and they're probably going to keep coming.
We're going to, and it's connected, we're going to talk about property rights in just a minute. If we have time, you may have some questions about the Trump cases, but when the government basically dictates to the private press, printing presses, what they have to run and not run, you should be worried. Now that's different than just jawboning. Government all the time, and this is what Edwina was talking about, calls up and complains, this wasn't a fair story, that wasn't a fair story. That can't violate the First Amendment, just government complaining that this news story is inaccurate or dangerous. Government has free speech rights too, and if they don't go beyond speaking, just in effect jawboning, it's really hard to say that's unconstitutional. Even if Louisiana wants to say that, they're going to lose. So the Fifth Circuit's Louisiana and Texas and federal judges there who have bought into, the social media, they lean toward the Democratic Party. Well, so does the New York Times, but that doesn't mean you can tell them what their op-ed page should look like, or their news page, for that matter. Now, that's a good segue, I think, into property rights generally. Again, if we have time, we'll talk about, I have some things to say about the Trump cases. But Zach, maybe you could just begin by telling us a little bit about the Grants Pass case.
Yeah, this is a really interesting case that was just heard a week or two ago about homelessness, and especially about tent encampments and camps, which have become a big issue in many cities across the country, I think particularly out west. And this is a case that came up through Grants Pass, Oregon, which is one of the many jurisdictions out west in particular, is sort of struggling with how to deal with rising homelessness and encampments. And they passed a law that made it illegal to basically it made it illegal to have a tent encampment, but they defined camping extremely broadly to include sleeping in public. I had the terms in front of me. I had the exact terms, but it's like sleeping in public with a blanket of any kind. So it's not just having a tent. It's extremely broad. A lower court in the Ninth Circuit responded in its own extremely broad way with an injunction that made it impossible for them to enforce this law for anybody who was involuntarily homeless. They basically struck down the law as being a violation of the cruel and unusual punishments clause of the Eighth Amendment, which is a little strange. You don't usually think of the cruel and unusual punishments clause as a basis for prohibiting a state from regulating something. You usually think about it as how severe can the punishment be. So it's a little bit of an odd fit. But the Ninth Circuit made it illegal to, or prevented the city from enforcing the law as applied to anybody who's involuntarily homeless. And they define that by just counting up the number of beds that were available in shelters in the jurisdiction, counting up the number of homeless people in the jurisdiction, subtracting the number of beds in religiously affiliated shelters, and sort of seeing if there was beds available at this aggregate level. So the case now comes up to the Supreme Court. I think this is probably an even easier one to make a crystal ball prediction about the bottom line, about the Supreme Court is going to hold that the city has the authority to enforce its camping laws at some level. But I think there's a very hard, or maybe two very hard questions sort of baked into this case that were the root of sort of how the Ninth Circuit got to where it got, which is there's some old Supreme Court case law suggesting or holding, sort of depending on how exactly you read it, that you cannot make a status a crime. The case held that you couldn't make it a crime to be a drug addict. You can make it a crime to possess drugs, you can make it a crime to use drugs, but you can't make it a crime just to have the status of being a drug addict. And one way to look at this law is it goes so far as to make it a crime to simply have the status of not having a place to sleep. And that's, so that is I think the part of the oral argument, a big part of the oral argument was the struggle of trying to figure out how do you define what is a status, like what is conduct, what is status, and in particular, what kind of conduct do you need to sort of get across the line? Because if the only conduct you're talking about that takes you out of the status is that you're breathing or sleeping, like it'd be the earlier Supreme Court case saying that you can't be a drug addict, make it a crime to be a drug addict, it would be quite strange if the state could just come back and say, well, it's illegal to be a drug addict in our state who's also sleeping, right? Because it's just like a biological necessity. Everybody needs to sleep. Everybody needs to breathe. And so it feels sort of like an end run around the principle that you can't criminalize a status. And then I think, relatedly, there's a very difficult question about necessity. This is like a related point in the law. There's a well-recognized defense in most criminal law, generally speaking, of necessity, that if something is truly necessary to do as a matter of like life or death, then sometimes basically the rule in courts is that you can actually just do it. And so sleeping is a biological necessity. If there is literally no other place for a person to sleep, there are no beds available, it's pretty intense to make it a crime to sleep on the ground on a cardboard box. Like and so the struggle in the court was how to sort of, I think, rein in a Ninth Circuit injunction that seemed to go much too far in terms of preventing the state from enforcing its law, but also to sort of struggle with the outer limits of, like, are we really going to go so far as to say you can make it a crime to sleep on the ground?
Dan, how much time do we have? Okay, so I'm going to say two quick things about this and then maybe get Edwina in if she wants to talk about another property rights case involving a thing called legislative takings. But Zach is right, the confusion here. Now, the Ninth Circuit is way to the left of the Supreme Court, just as the Fifth Circuit is way to the right. And it's just a feature of the fact that although presidents are making appointments, they're making appointments in combination with senators, and the senators from the West Coast, lean very far left, and the senators from the old Confederacy, that's the Ninth Circuit, senators from the old Confederacy, the Fifth Circuit, are leaning far right. So the Fifth Circuit is way to the right of the median justice on the Supreme Court, Ninth Circuit is way to the left. Now, here's what they have on their side. They have a Warren Court opinion. It's called Robinson versus California, and although I haven't written about this, here's how they should distinguish it. Robinson was a case about a statute that was construed by the California Supreme Court explicitly as criminalizing the status of being an addict in California, which meant the following. If you had never done any affirmative act, but someone had kidnapped you, injected you with heroin for years, and then just released you on the street, you'd be a criminal from the minute you actually walked on. That seems a little weird. No mens rea, no actus reus. Okay. If you had taken drugs lawfully in Nevada, because you can do all sorts of things in Nevada, apparently, I'm told, that you can't do in California, and then you walked across the street, the Sierra Nevada line to California, you'd be a criminal. And what about the rights to travel? You can do things legally in Nevada that you can't do in California. So and Robinson was weird. They called it cruel and unusual punishment, which, as Zach said, is usually about death penalty or life imprisonment. It's about criminal punishments and not whether you can criminalize something at all. Got the right result because there is a right to travel, and they were actually they were criminalizing someone who had never done anything before. Here's how it's different. This one, and I'm not sure anyone said this in oral argument. Because I've just been there twice in the last 2 weeks. I grew up there. California, it turns out, it's a big place. It's a very big place. You know what? Grants Pass is not. Now, technically, the 14th Amendment applies to cities and counties and the state, but actually, all this doesn't say you can't sleep. It says you can't sleep in Grants Pass. And as long as Oregon is okay with this NIMBY law, Oregon could say, no, we don't want individual localities to do that, because then they'll all do that and ship out their homeless people. But if Oregon is okay with that, actually it doesn't criminalize anything except being in Grants Pass. And there are other places in Oregon you can be. So we will see whether the Supreme Court picks up on these very nice little technical things. That technically doesn't regulate status. It's not dealing with conduct out of state, because you can't easily get from out of state to Grants Pass, just where Grants Pass is. It's not on the border the way actually the California law. Literally, you just cross the state line and you're a criminal. Okay. So Edwina, if you want to just say a brief word.
Yeah. Well, we can briefly, but we actually this one's been decided.
Yes.
So
you can make a prediction.
Yeah. I was going to say it could be a very cheap prediction. So this was a case where somebody was trying to build a house on their property, and they had to pay $23,000 in a permitting fee to build the house. And the question was, does the Nolan-Dolan line of cases, which talks about the rules for a administrative taking, so you go to a town board and say, I want to build something, and they say, well, you have to pay this thing first, specifically to you. Do the rules that apply to that apply to a legislative taking, so a law that says everybody has to pay this certain permitting fee to build their house? And the court 9-0 said yes. So it's been...
So your prediction is?
Yes, 9-0. But the work is going to be done, I think, later, because there were concurrences, and make sure I remember this probably, but Justice Gorsuch, came out and said, we haven't said anything about whether there's a different kind of analysis if something applies to an individual versus a group of people. And then in response, Justice Kavanaugh filed a concurrence saying, we haven't said anything about that. But Justice Gorsuch said, but I don't see why it wouldn't. I don't see why the same kind of rigorous analysis wouldn't apply. And Justice Kavanaugh responded with his own concurrence saying, we haven't addressed this, and we haven't said that kind of permitting rules that calculate fees based on a certain schedule, based on the property, wouldn't be okay. So there's clearly some dispute in the concurrences, and that's going to continue. But no, it was a 9-0. Nolan-Dolan applies, and requires basically a connection between the permitting fee and the thing you're trying to do, and it has to be proportional in order to assess a fee. So yes, I predict 9-0 with 2 concurrences, one by Justice Gorsuch and one by Justice Kavanaugh.
Now, lots of time for questions. We haven't talked about the mifepristone case. We haven't talked about the Sackler bankruptcy case. We haven't talked about the Trump cases, and there may be others that you all want to talk about, so we've left some time.
Ben. Thanks. I actually had 2 questions for 2 panelists. Well, one is more of a quick statement, and the second one is a question. So the first one is for Zach on the Loper-Bright case. I filed a certain merits brief for NELF in that case, and I have a different. Should I stand up or just stay seated? Okay. I have a different take on the case. Again, it could be just my narrow focus, but my understanding of the case was that there was no ambiguity on the face of the statute. It was clear that when the statute simply says that the government can require the fisheries to carry on board federal observers. Carry on board means to house. It even uses the word quarter, 2 or 3 sentences later. So clearly it's a question of accommodating. It's nothing about paying daily wages. And we know, of course, throughout the statute there are isolated particular examples where Congress has gone out of its way to say, yes, in this instance with the Pacific fishery or with foreign fisheries, you can shift the costs onto the the fishing industries. So the classic rule of construction, well, it was silent here, that must be a deliberate omission. So in other words, my point is that I don't think this case should ever have gone past Chevron step 1, which is there a federal court exercising its Article 3 powers, rolling up its sleeves if it has to, applying the traditional rules of interpretation, which are based on reasonable inferences, which Chevron does state in that magic footnote, which has been established forever anyway, and it's also basically what Marbury v. Madison says too, in essence.
Let's just hold that one, and then you come back for the second one because we want to make sure that lots of folks get involved.
So
my point is,
I think he got it. Chevron step 1 and the statute.
And it should never have gone past that. In the D.C. Circuit, in its misconstrual of Chevron with some unfortunate language in Chevron, misunderstood its role, or rather, if you will, abrogated its role in a way.
Yeah, I mean, I think this is probably the least the Supreme Court is going to do is to make that much clearer, is to say that in order to determine whether the law is ambiguous, whether the agency has this discretion, you really need to dig in, roll up your sleeves, do a detailed analysis of the law, determine whether Congress has really given this policy-making authority to the agency. That's basically the thing the Supreme Court has done itself consistently for the last decade, but it hasn't really rigidly told lower courts that they have to do that.
So Zach, you're saying you don't have to overrule Chevron if you don't want to. You can water it down by limiting its scope, which is called, in the lingo, Chevron step 1 or even Chevron step 0.
Yeah, and they did something similar in a case a couple years ago called Kaiser versus Wilkie, involving a different agency doctrine, that our doctrine or Seminole Rock deference, but where I think there was a lot of thought that they were going to overrule it, get rid of it entirely. I think there was a lot of conventional wisdom that was going to happen, and instead what they did was they reined it in. They clarified that this doctrine was much more limited. It had real guardrails around it, and so it only arose in certain circumstances. So they could Kaiserize the Chevron doctrine and constrain it and agencies that way. That's, I think, one of the serious things that they were talking about in detail in the argument that is on the table.
And there have been other things that have constrained Chevron too. The major question doctrine, other kinds of deference that are just, well, the agency might be expert on certain things, and those are different sorts of deference than Chevron deference. So I think your prediction was that the Fisher folk are going to win, the bureaucrats are going to lose, but we don't know exactly whether it's going to be a sweeping overruling of Chevron or some limitation.
That's exactly right. Yeah.
Okay. We'll come back, because I just want to make sure everyone else gets a turn. Okay, if none of you want to turn, he's going to take a second shot. Okay.
Sorry, I don't mean to hog this. So this is a very, maybe, again, naive question, but on the First Amendment issue concerning social media, you alluded to the court's, I guess, traditional distinction between a common carrier and the press. Now, how viable is that distinction? I'm trying to simplify my question here. Does that distinction hold up now when we try to apply it to the social media, which seem to have arguably elements of both, on both lines of that dichotomy? So how helpful is that distinction, if you will, in this modern, very modern question?
I think it's a great question, and I'll answer it with another question, which is to say one of the things that came up at the argument and that I think really needs to be grappled with is a lot of the social media companies use something called Section 230, which is the Communications Decency Act, which says that they're not speakers, right? They are just providers of internet, and thus they can't, it's somebody else's speech, and so they can't be held liable for it. That's why, any sort of tort cases, et cetera. And there was, I think, a very prescient question, I can't remember who asked it, at the argument that basically said, well, you've been telling everybody you're not a speaker under Section 230, so how is it now that you have freedom, you're actually speaking and this is your First Amendment right? There was not a good answer given to that question. I don't think that issue is actually teed up by this case. I think it is going to be, and as Zach alluded to, there was a big Section 230 case last year that they punted. It's going to come back. There will be this question on joining issue of the intersection of Section 230, which is really your question about, social media versus, are they actually a common carrier? Are they a provider of sort of a common square, or are they in fact engaged in some First Amendment activity and speech themselves?
I have one question from the studio audience, and the question to the
and then we
panel.
also have this gentleman over here after that.
The question to the panel is: would you like to see the Supreme Court expanded, have term limits, both or neither, and why?
I'll jump in on that one, and because we didn't get a question about Trump, the Trump cases, but I have a free weekly podcast, and you could listen to it. There are 3 different, we've done it for 3 years now, every week, 180 episodes. Our first one was taped on January 6, 2021. There was some other interesting things that happened on that day you may have heard. And there are 3 different episodes on a proposal that I first made 20 years ago in the Washington Post for 18-year term limits for justices. So you could hear 3, each episode is called, the podcast is, as I said, free, and you can get CLE credit. It's called America's, not America's, America's Constitution. And the first one was called 18 Arguments for 18 Years, and then there were 2 others based on my testimony before the Biden Judicial Reform Commission, and then when the Judicial Reform Commission issued its report. I take the position that term limits would be a good thing, that 18 years is the perfect number because it divides nicely by 9. There's a new justice every 2 years. Every president gets 2. And there are 18 different reasons. Right now, each party is tempted to pick someone too young to maximize in an arms race, its clout on the court, and people stay too long because arteries harden, they time their resignations in ways that actually are political. A better model of judicial independence, like the model of this state and most states, is actually fixed number of years or mandatory retirement rather than life tenure. Only one state in all of America has the life tenure model. That's Rhode Island, which is not the best governed of the states. No other major democracy does it. There are lots of reasons to do it. You can do it, I claim, without a constitutional amendment if you structure it the right way, technically you're on the court for life. You're a justice for life. You keep your salary for life and your title, but after 18 years, your job description shifts and you tend to do other things. You're available to pinch hit if the court is short-staffed, but you do more administrative things, ceremonial things, public relations things, meeting with foreign dignitaries. You ride circuit. You do other things that the court needs to be done. And it could be done, as I said, I think without a constitutional amendment. Several justices have actually indicated an openness to this idea. They don't like packing the court. They don't like getting rid of judicial review. They don't like all sorts of other way left reforms that have been suggested. But Stephen Breyer has said, oh, I'm open to this. I think John Roberts has actually said this seems like an interesting possibility. So stay tuned. When I first launched this in the op-ed in the WashPo, I'm a Democrat. I did so in a co-authored piece with a registered Republican who's a co-founder of the Federalist Society, Steve Calabresi. The late, great professor, and I'm having a senior moment here, he just passed away, Charles Freed, supported this idea. We actually did an event at the EMK Center 4 months ago in Boston. The American Academy of Arts and Sciences has endorsed the idea, so it has bipartisan support. And thank you, Felicia, for that. Charles Freed was a great professor at Harvard. He was on the Massachusetts Supreme Judicial Court. He was Solicitor General of the United States in Republican administrations, a very well-respected, traditional conservative, and he thought this was a good idea. So do folks on the left of the spectrum. You might hear more about it in the future.
First of all, I want to thank everyone for the great presentation. It was really informative and fun. Second, I want to put in a plug for Professor Amar's book, which I picked up last year here, and it's very informative and very readable. My question, though, is back to the free speech cases. Clearly, both people on the right and people on the left are interested in using social media companies either to promote their own message or to prohibit people on the other side from promoting their message. And clearly the government has a lot of ways to make the life of any business miserable, ranging from legislation to quiet suasion, if you will. If you had to write the majority opinion for the Supreme Court, trying to draw the line between what the government can do and can't do, where would you draw that line?
Okay, well now I have to be Professor Amar suggested we're all going to be Supreme Court justices, so I think I would go with in terms of the Murphy case, I think I would go with the coercion versus not coercion line. Now how that plays out in terms of facts of this case, I don't know, but my sense from argument, at least from the Louisiana Solicitor General's argument, is that he doesn't think he can win on coercion in this case.
It connects to your standing issue also, doesn't it? Because if the companies aren't complaining, that should maybe tell us something, or maybe no.
Yeah, no, I think that's right. I think that's right. I think I would draw that's the precedent is coercion. That was, I can't remember the case now, but it starts with a B. Anybody remember? Anyway, there's this case that says that you have to have coercion. So I would draw the line at coercion. I think that actually is what Justices Alito and Thomas were talking about when they talked about threats of antitrust actions and threats of Section 203 or 230 actions. I think that they're getting at coercion. So I tend to think, which is why I was kind of aggressive with my numbers, and I might even be more aggressive with my numbers, but I tend to think they probably all would agree to some respect on the legal rule and maybe disagree on what the facts show here. I think that's where I would draw the line, coercion versus something else.
There's also another case that's up this year with a similar fact pattern called NRA versus VULO, where the New York insurance regulator was leaning on insurance companies and banks to stop doing business with the NRA because of its message. And I think there the evidence, or at least the allegations of coercion, seem to be carrying more weight with the justices. And so I think one thing we could see is a split on the outcome of these two cases, where even though they're applying a sort of similar legal rule, the social media one is found basically not to be coercive, whereas I think it's likely that the NRA will, not that they will win outright, but it'll go back down for sort of further proceedings.
Thank you very much. I want to thank Professor Amar as well as our panel, and thank all of you. Let's have a hand for our panelists here today. Thank you all very much for coming. We have refreshments in the back and copies of Professor Amar's book in the back as well. Please stay and join us for some informal conversation off the mic. Thanks so much.